has been released on bail. What are protesters being charged with and what penalties might they be facing? Karen McArthur and Mohamed El-Rashidi are two criminal defense lawyers and both are in Toronto. Thank you very much for joining me.
You're welcome.
Thank you, Dave.
Karen McArthur, I'd like to start with you if I could. Police have made arrests, more than 100 people so far, 21 vehicles towed, and most of the charges seem to be multiple various offenses including mischief and encouraging mischief. So what's at stake for the people charged with those offenses?
Getting a criminal record, spending a couple nights behind bars, having a permanent stain on their record. Going forward, employment prospects dim. They are facing legal bills and uncertainty for bringing forward their values, for expressing their opinions.
Well, is that what the mischief charge will constitute? I mean, if you've been in the downtown core of Ottawa, I mean, it's quite the occupation. There's been a lot of harassment. I mean, is this really a criminal charge arising from a protest, as you've kind of described it?
Well, no, a criminal charge for mischief lies when you obstruct or interfere with anyone or a group of people's lawful and reasonable expectation that they have the right to use their property. So the good citizens of Ottawa, some of whom I've received phone calls from today, expressed their serious discontent with the Freedom Convoy occupying their streets and indicated in their voicemail messages to me what a grave disturbance this has been to their going about their lives for the last 22 days. Does that constitute mischief? It may well, in fact, constitute mischief. The particulars of the mischief will have to be laid out with proper grammar in this charging document that in Canada is called an information with a capital I. So it will say Chris Barber or Tamara Leach did cause or counsel mischief in the following ways.
Okay, Mohamed El-Rashidi, I wonder if I can bring you your thoughts on the seriousness of this. We're hearing that mischief is maybe an initial charge, Could further charges be laid down the line?
Yes, I think, everything, I concur with Karen exactly as she explained. It is a little bit, it's not surprising that mischief has been laid. It does lay the groundwork for further investigation as well as charges to come. I think along with the other consequences that Karen has mentioned, one of the serious consequences for protesters may also be the inadmissibility into the United States, because the United States does not allow visitors into the country who've been convicted of crimes that are considered crimes of moral turpitude, which was probably a very serious consequence for some of these people who wish to go to the United States. But in terms of the big picture, more serious charges are likely, and quite frankly, to hear the rhetoric or to hear the allegations that were being made in Parliament in terms of the use of violence, in terms of threatening to overthrow government, of course, if in any way what is happening in Ottawa is connected with the weapon seizures at the border with Coutts, which starts to open up the Section 83 potential domestic terrorism type of approach and national security issues, you start to really open this up into something that's far more serious for the protesters. But at this juncture, mischief and counseling in relation to mischief is going to suffice to get some of these people at least arrested and processed within the system.
Yeah, certainly what we saw in Coutts, Alberta is far beyond anything that has been substantiated here in Ottawa. We want to be very clear on that, despite rhetoric about ideological links between the two groups of protesters. But Mr. El-Rashidi, just quick on the mischief issue, so what kind of jail time could you be looking at? What kind of financial penalties could you be looking at? What is the sort of range of punishments someone could get if they are in fact convicted of this?
Well, to be clear, mischief gives a lot of flexibility. I think seeing the magnitude of what's unfolding before us, mischief for people like us who are in court all the time is somewhat surprising in the sense that it is not viewed as a serious offense. However, you can upgrade mischief. You can apply it as an indictable offense, which would lead to far more serious consequences. So the imprisonment can go to up to not exceeding 10 years in jail. Obviously, I don't think that is going to be applied without something even more serious brought forward. But to answer your question, succinctly, you're looking at up to 10 years in jail. And then, of course, the overwhelming majority of people don't go anywhere near that kind of time frame for imprisonment. But look, it is very serious. If you do want to go on with your life and you want to have a prosperous life in the society, being convicted of mischief is definitely not going to help that. But I don't view serious jail time as very likely under these charges. I think there's going to have to be more brought about, certainly in terms of allegations, to back up something more serious than a slap on the wrist.
No, certainly, Karen McArthur, as you said right off the top, it's the fact that you get a criminal record out of this, which is a significant impediment to the proper functioning going forward in terms of your professional life and your ability to cross the border. And I wonder, I'm not going to ask you to speak to the specifics of the charges against Chris Barber, but we do have his bail conditions. And Karen, I wanted to get your reaction to that. So he's been charged with counseling to commit mischief, counseling to disobey a court order, counseling to obstruct police, and mischief itself. He was released, but he has to leave Ottawa 24 hours after being released from custody, has to leave Ontario by Wednesday at midnight. He can't support the convoy in any way, except he can pay for things like gas from his own pocket if it facilitates truckers leaving the city. I mean, what do you make of those bail conditions? Are those normal, or those seem kind of unusual to me?
Asking someone to vacate or get away from the scene of the crime is something that I have seen where the police or the Crown or the judge imposes geographic restrictions. That is not unusual. Are there any non-communication clauses?
He's not allowed to support the convoy in any way, so I would assume that captures communication. I don't think he's allowed to speak with the other organizers or have any contact with them as well. I think it's basically get out of town, stop talking to people, and the only thing you can do is give gas money for somebody who wants to leave.
I'm surprised that he got out of bail got on bail as quickly as he did. First day out, particularly because he, unlike Tamara Lich, is charged with breaching the court order, and I think it's the court order of Justice McQuad. So he's charged something additional, and he's made bail already. Was there a surety? Is this a surety or his own recall?
His wife is his surety. He's due back in court on the 1st of March. So it's that sort of standard. I guess she had to put up the bond and be responsible for it. And so that's all the details we have right now at this one.
I think that will set the mark for everyone else that's been arrested today. If Chris Barber is made bail, then the rest of the bodies will be, we use the term the bodies, they will be processed and they will be released as quickly as possible. So most of those that have been arrested today, going from Chris Barber's precedent, I think will be out in a few short days. If they have someone that can come and post bail for them, act as a surety. A surety is basically a jailer on the outside, someone guaranteeing that you will comply with the terms that you've entered into in the bail.
Right, and Mohammed, sorry, go ahead.
Some of these folks may not have somebody to come forward and do that, and if the Crown insists upon that, then unfortunately they will sit in jail.
And Mohammed El-Rashidi, that's one of the challenges here, too, because the money that was flowing in to support this organization has been largely cut off or seized. Their bank accounts could be frozen because of the Emergencies Act. And Tamara Lich, who Karen McArthur mentioned, has been arrested. She, because of delays in court today, she won't be in court until tomorrow morning. She's back, I think, at 9:30 or 10:30 tomorrow morning. But I'm wondering what's your reaction to these bail conditions and what it means of how the court's going to deal with this.
Well, you know, there's a practical aspect to this. An individual does not have to agree to any of these conditions, and then they can have a bail hearing and they can go ahead and challenge it, preferably, of course, with the use of a lawyer. So at the end of the day, whatever conditions you have before you, if you don't like them, you challenge them. And so he does not, and she does not, they don't have to agree to these things. They can always challenge them. That's really the point here. And so I don't, you know, you always want to be sympathetic. Of course, you always view people as innocent until proven guilty. But at the end of the day, any condition imposed on you is something that you can challenge. You're accepting these conditions when you get out, as Karen said, as quickly as they do, and so that means they're agreeing to it. And of course, it becomes a financial challenge when you don't have money to hire somebody, but there are things in place to get you legal counsel, even if you're not able to pay for one in Canada and in Ontario. So it's not a situation where these people don't have a choice. They're making a calculated decision to accept these onerous conditions in exchange for being released quickly.
Karen McArthur, I wonder if I could get you to weigh in on the whole issue of the use of the Emergencies Act in this. I mean, it's a very controversial political issue with civil liberties organizations and certainly the Conservatives and the Bloc Québécois saying that this is drastic overreach by the federal government. What's your sense of how it has been applied and how the measures in these emergency orders have been used by police to deal with the situation in Ottawa?
My sense is this: there were already in the works two pieces of litigation that have resulted in two bona fide court orders. The court order from Associate Chief Justice McWatt, which basically said, get these streets cleaned up. That's an order of the court. I want that enforced. And the order of Justice McLeod last night, as a result of the class action suit brought by the citizens of Ottawa, to freeze bank accounts of people that were involved. Both of those court orders were obtained in the normal course through the court process that has checks and balances built into it, although the court order last night was obtained with only one side of it because it was a Mareva injunction. Mm-hmm. So those participants in the Freedom Convoy didn't get to have their voice heard. Their voice can be heard later after they're served with the order, and then they have an opportunity to make representations as to whether or not the court order was fair. But in the normal course, two significant court orders were obtained. And so I asked parenthetically, was it necessary to reach into that toolkit or that toolbox of the Emergencies Act, or is it in fact draconian overreach? I tend to think, stepping out here, that it may have been a bit draconian, given that access to the courts was obtained and orders did issue that touched upon the conduct that is of concern to the citizens of Ottawa, to the people living in Ottawa.
Mr. El-Rashidi,
the fact it just gives too much power to the government.
Mr. El-Rashidi, what's your sense of it? Because the police have made the point they couldn't deal with this until they were able to get the extra authority under this act. What's your take?
You know, there's a couple of ways of looking at this. I agree with Karen. Look, as a general rule, we don't need to give police more power when it comes to dealing with any kind of allegations. That should be made very clear. In Canada, we give tremendous powers to the police as it is, and so I agree with Karen on that. This was quite a lot. However, we have gone on for 22 days. The police have not been able or unwilling, or whatever the end result through inquiries will determine, to remove these protesters and deal with it in a definitive manner. So something further had to be done insofar as they are concerned. Was that necessary? It's very difficult to justify giving further powers to the police after everything that we've seen. But it should be important to note, David, this point that this act was passed, of course, by the Conservatives, by former Prime Minister Mulroney, and there's a bit of irony going on here from a legal perspective, that you're seeing, one side of the political aisle claiming, where are the charter rights, which are obviously something that Trudeau and Pierre Trudeau have brought about, and then you have on the Conservative side, criticizing the use of the Emergency Measures Act, which a Conservative government brought about. So it is interesting to see them switching sides here to some extent, and we'll see how it plays out. But overall, do we need to give more powers to our police and to our governments? The answer from people who care about civil liberties and people who live day in and day out in the courtrooms, we don't need to do more of that. That is something I definitely stand against, and I know that my friend will say the same thing.
Look, I appreciate you trying to make sense of the inconsistency of the political parties, but if you try to do that too often, you're going to tie your brain, and it's a hard thing to do. We try to do it for a living. Look, I want to thank you both. We really appreciate the insight. Karen McArthur, Mohamed El-Rashidi, thank you for joining us tonight.
Thanks for having me, Mohamed.
Okay, we're going to show you the scene